Hello everyone, welcome back to your channel JLX Current Affairs. Well, this is the first informative video of mine, and in this video we will be discussing about the judicial matters that were in the news between 14th of January to 20th of January. So, without taking much time, let's get started. As we all know that President Ramnath Kovind has given an assent to the 104th Constitutional Amendment Bill, which is now 103rd Constitutional Amendment Act, providing 10% reservation for economically weaker section of the society.
Now let us understand the important component of 103rd Constitutional Amendments. One of the important component is that it partially changed the fundamental rights, that is Article 15 and Article 16, by inserting Article 15 Clause 6 and Article 16 Clause 6 to the Constitution. And the other important components of the amendment is that it aims to fulfill the commitment of the directive principle of the state policy under Article 46, which is to promote the educational and economic interest of the weaker section of the society. Now let us look at the criterion for reservation. To be a part of reservation, people has to have an annual income less than 8 lakhs, or people who have less than 5 acres of farmland, or people who have a house less than 1000 square feet in a town or 100 square yard in a notified municipal area.
Just after the passing of the 103rd Constitutional Amendment Act, the organization called a not-for-profit organization, Youth for Equality, has questions the constitutional validity of the 103rd Constitutional Amendment Act, which provides 10% reservation for the economically weaker section.
Now let us understand why the organization called a not-for-profit organization, Youth for Equality, has questioned the 103rd Constitutional Amendment Act in the Supreme Court. The first reason they says the amendment which insert Article 15 Clause 6 and Article 16 Clause 6 would alter the basic structure of the Constitution and annul various binding judgment of the Supreme Court. The second reason they says the Amendment Act violates restraints that were imposed in the reservation policy, that is the 50% ceiling limit and the exclusion of economic status as a sole criterion. The third reason they says the expression economically weaker section remains undefined by the amendment and was to be notified by the state. The fourth reason they says it is unclear whether the central government or the state government can both define the expression separately.
The Supreme Court has issued a notice to the central government on PIL which questions the central government notifications authorizing 10 central agencies to intercept, decrypt and monitor any computer system, and also the Supreme Court has asked the central government to respond to the issued notice within 6 weeks.
Now let's be aware with the 10 central agencies who were authorized by the central government notification to intercept, decrypt and monitor any computer system. The first is Intelligence Bureau, the second is Narcotics Central Bureau, the third is Enforcement Directorate, the fourth is the Delhi Police Commissioner, the fifth is Central Bureau of Investigation, the sixth is Directorate of Revenue Intelligence, seventh is Directorate of Signal Intelligence, eighth is the Central Board of Direct Tax, the ninth is the Research and Analysis Wing, and the 10th is the National Investigation Agency. Now let's understand the ground on which PIL has challenged the notification of the government. The first ground is that the notification was illegal, unconstitutional and ultra-vires to the law. The second ground is that the notification gives states the right to access every communication, computer and mobile, and to use it to protect the political interest and the object of the present political party.
Friends, the Supreme Court has rejected the plea of the states of Punjab, Haryana, Bihar, West Bengal and Kerala, which sought implementation of their local laws regarding the selection and appointment of the DGPs. Rejecting the petitions of the state, a bench headed by the Chief Justice Ranjan Gogoi held that the directions earlier issued by the Supreme Court on selection and appointment of the DGPs were issued in a larger public interest and to protect the police officials from political interference. However, the Supreme Court has granted some relaxations to the state which already had some local laws in regards to selection and appointment of the DGPs by giving them an opportunity to move a plea before the Supreme Court seeking modification of the order. Accordingly, the state of Punjab, Haryana, Bihar, West Bengal and Kerala have sought modifications of the Supreme Court order by citing their local laws. Friends, President Ramnath Kovind has appointed senior advocates Sanjay Jain and K.M. Natras as Additional Solicitor General of India. Friends, now let us understand who are the members and the functions of the Appointment Committee of the Cabinet. The Appointment Committee of the Cabinet is headed by the Prime Minister and the Home Minister is the member of the committee. The Appointment Committee of the Cabinet is responsible for making recommendations of the several important positions of the Government of India. Friends, now let us understand who is the Additional Solicitor General of India. The Additional Solicitor General is the third important law officer of the country in the hierarchy. Friends, the Additional Solicitor General is neither statutory nor constitutional, but is governed by the Law Officers Condition of Service Act 1987.